Hey everybody, welcome to my YouTube channel, Foreclosure Help 777. This is my Facebook page, which is also called the same thing, Foreclosure Help 777. If you have any questions, or if you're in foreclosure and you want some advice, or you want me to look at any of your documents that are suspect, you can send me an email at foreclosurehelp777@gmail.com. Okay guys, today we're going to give an update on Sabrina's case. Sabrina Kohler, she's in the Eastern District of Missouri in the federal court. In the docket, this is what her case looks like. And there's her case number, 423CV01332, RLW. And that stands for Ronnie L. White. Kohler versus New American Funding. And you can see that she filed her documents. She's the plaintiff. She filed them on 10/23/23. The last filing was on March 26, 2024. So let's look and see her case and what's going on with it right now. As you can see, she did file a complaint, and you can see that her summons returned executed. And then the entry of appearance by the attorneys was next. Okay, they asked for an extension of time to file a reply. They filed a motion to dismiss. Okay, now she filed an opposition to motion to dismiss. Now let's go down here a little further, because what happened was she filed a motion to dismiss. I'm sorry, she didn't file a motion. The bank filed a motion to dismiss, and then she filed, instead of an opposition, she filed a leave to file an amended complaint. So she filed an amended complaint. Let's keep going down here, guys. Then they filed a new there's her amended complaint on 2/5/24. Okay, memorandum. And then motion to dismiss. And then she filed a response to their motion to dismiss, which was another memorandum and reply to motion. And then she filed, the other side, there's two different defendants in this case. They filed a motion to dismiss, and so she had to file in opposition to their motion to dismiss. And you can see the memorandum in opposition to motion on 2/29, the memorandum of opposition on 3/20/24. And those are two different defendants. Okay, so then they filed a reply. You see where it says reply to response to motion? Reply, okay. And so then the plaintiff, Sabrina, she filed what's called a surreply. And that's what you file. You file leave to file the serve reply. You can see on 3/11/2024, she filed a motion for leave, and that's for a surreply. And then on 3/26/24, she filed a motion to leave to file a surreply. And so the way it works in federal court is, it's something everybody that's pro se should know this. But basically, you file your complaint if you're the plaintiff, and let's say you're suing the bank. So you file your complaint, and then they file a response, usually a motion to dismiss. So then you file an opposition to motion to dismiss with memorandum of law in support of your motion to dismiss. In support of your opposition to motion to dismiss. And then the other side files a reply. And then it's considered fully briefed. And so at that point, if the plaintiff thought that she needed to say something back after they filed their reply, then you file for leave to file what's called a surreply. And we can look and see what that looks like. Okay, so first is you file leave to file a surreply. Motion for leave to file, because you have to ask the court permission first, and then you attach a proposed surreply. So that you can see this is what she's doing. She's saying, she's asking for the court for leave to file a surreply. And then she signs it. And then her proposed surreply goes with it. like steak and baked potatoes. You got to have your proposed surreply submitted with your motion for leave. And this is what she basically argued back some points that the defendant made on their reply. And you can see how she's responding here. Like, let's look at the first one real quick here. On page 1 of defendant's reply memorandum states the following. Because plaintiff has failed to state any claims against MidFirst Bank upon which relief can be granted, the court should dismiss every claim against MidFirst Bank with prejudice. Plaintiff's response to this is the claims against MidFirst or Midland Mortgage should not be dismissed because it now owns all the servicing records that the plaintiff can show prima facie evidence through discovery to prove that she is indeed entitled to relief. On page 2, the defendant states the following. Plaintiff seems to be arguing that because successor mortgage servicer liability may exist under the MMPA, that it must also exist under the FDCPA as well. Plaintiff responds that the MMPA was enacted to protect consumers by expanding the common law definition of fraud, to preserve fundamental honesty, fair play, right dealings in public transactions. Conway, and then there's some case law to back that up there. The use of an unlawful practice is a violation of MMPA, whether committed before, during, or after the sale of merchandise, so long as it was made in connection with the sale. Plaintiff stated in the First Amendment complaint on page 8, number 11, that Exhibit M, that Midland Mortgage sent monthly statements showing an amount due for a loan which she does not owe. They are liable under both the MMPA and the FDCPA. A successor mortgage servicer is liable under the FDCPA if they acquired the debt after it was in default status. Defendant did not prove that the loan was not in default status when they acquired the loan. Therefore, defendant's argument stating they are not liable under the FDCPA fails. And then it says, defendant stated on page 3, defendant did not plead in her First Amendment complaint that she notified a credit reporting agency of the disputed information as required to state an FCRA claim. To this, plaintiff responds that on page 23 of the First Amendment complaint, she stated that while she did notify Experian that there is a record of this dispute and data online, the fact remains that both New American Funding and Midland Mortgage ignored her numerous telephone calls, emails, and letters. Plaintiff added screenshots showing credit scores. FAC Exhibit L. Okay, now we won't get into all this during this, but I just wanted you to see what it looks like when you're writing a surreply. You need to basically argue back what they said in their reply, which is what she's doing. So you basically want to, what we do is we put it in single spaced. For instance, on page 4, the defendant's reply motion states the following. She does not actually state a claim for quiet title against MidFirst Bank or NAF among her 11 discrete and numbered causes of action. Because plaintiff did not state a claim for quiet title in her First Amendment complaint, she cannot state such claim for the first time in her opposition brief. But she did state it. In response, plaintiff states on page 11 of her First Amendment complaint, it states following quiet title action. So, I mean, they will lie when they write their motions, and you have to call them on every single thing that they say. And that's what this surreply does. It basically catches them on their lies. There's a conclusion, and then she signs it. The conclusion says, based on the foregoing, the plaintiff's case would be prejudiced if the complaint against Midland was dismissed prematurely, especially before the completion of discovery. The plaintiff's First Amendment complaint as a whole demonstrates that it meets the requirements established under the federal rules. The FAC, which stands for First Amendment complaint, satisfies the federal rules of civil procedure 8-9B, which creates a heightened pleading standard for fraud claims and requires that lawyers plead circumstances of fraud with particularity. The less stringent standards of this case, being pro se, still provided the who, what, where, why, and how of the fraud with particularity. The Rule 12b-6 motion to dismiss argument fails because the plaintiff has stated a claim that relief can be granted. Okay, so there you have it. Guys, this is what a surreply looks like in the docket. And you can see she's at docket number 50 at this point. So we have to just play the waiting game at this point. Everything's been fully briefed, as they call it. So we got to wait for the judge to issue a memorandum, an order, which will be the next thing, or they'll do a report and recommendation. So stay tuned, guys. We'll give you an update as soon as we get the next bit of info. I hope everybody has a wonderful day.